A very good evening to everyone present here. I'm more grateful to stand here and welcome you all to the first session of the quindecennial lecture series organized by MMBA. Thank you all for joining us. Before we start, I would like to extend a warm welcome to the respected President, General Secretary, and all the office bearers of MMBA. We are grateful to our Chief Guest, Honorable Mr. Justice S.S. Sundar, Administrative Judge, Madurai Bench of Madras High Court, for accepting our invitation and becoming a guest speaker of today's event despite of Lordship's tight schedule. We welcome you, Lordship. Now, I would like to welcome the President of MMBA, Srinivasa Raghavan, to address the gathering. Welcome, sir.
Happy evening to one and all. This lecture has been pending for a long time. And we have been waiting for your Lordship to address this particular topic. And the patience has come to an end today in this auspicious occasion. We all know, many of us, or most of us, without knowing the implications of the legislations, when we frequently use the terms, uses the sections, provisions, and the Act without any or insightful study of the subject. And one subject is the land tenure legislations, allied rules and regulations, and the procedures emanated from the Mughal rule and culminated till the recent past. So it was actually planned last year to have this session, but we were waiting for His Lordship to come to Madurai to sit here as an administrative judge and give this session today. And I'm very happy to be part of MMBA to arrange for this session, which will be meaningful to a few select lawyers who are interested in practice on this side. I'm very happy to welcome Mr. Bhaskaran, Additional Advocate General, Mr. K. Balasundaram, Senior Advocate, former Secretary of MMBA, Ms. Krishnaveni, Senior Advocate, former President of MMBA, Mr. T.S.R. Venkatramana, Senior Advocate, Honorable Mr. Bharata Chakravarti, who is present now, Mr. B. Saravanan, Senior Advocate, and Mr. Pathasarathi, Ramesh and Ramaya, Madhavan, Mr. Aayiram, Ganesh, who are all very much having expertise on this subject. And a young brat like HRMC and Atif, who are here present with all the zeal and interest. And I welcome one and all for having chosen to be here despite functions in Friendly Bar Association today at the same time. And I once again extend my welcome to one and all. More importantly, I am very happy and privileged to extend my hearty welcome to Honorable Mr. Justice S.S. Sundar, who is present today to deliver his exuberant lecture. Welcome, sir. Thank you, one and all.
Thank you for your warm words of welcome, sir.
It's a time for honoring our chief guest. The President of MMB and Secretary is honoring the chief guest with memento. Thank you, sir.
Now it's time to begin with the quindecennial lecture series 1 organized on behalf of MMBA. I would like to welcome our chief guest and guest speaker, Honorable Mr. Justice S.S. Sundar, Administrative Judge, Madurai Bench, to deliver his lecture on the topic Land Tenure in Madras Presidency and Legal Implications of Ryotwari Settlement. Welcome, Lord.
Good evening to every one of you here. I'm really proud of being here actually as an administrative judge. Always I used to enjoy the place, even as an advocate stuff. And this topic, literally speaking, is required for all the advocates to know the basics, because there are varieties of laws actually if you go in there. And then at least some of the legislation if you follow, you'll be able to understand more about the present day problem. Because often we are sitting here actually, people come with actually writ petitions to remove encroachment, even in respect of a pathway or even in respect of a conservative lane normally provided inside. This property doesn't vest with the government. Therefore, where the scope for invoking? So when we try to make people understand, yes, actually I feel that this is an opportunity to actually tell you something about that, so that you will now come up with actually new ideas, and then you will go into the problem, go inside the problem, and then find out what would be the solution in all these cases. South India originally was never subject to any invasion by actually Mughal emperors. This is what actually you all think. But they have somehow captured many places by peaceful means. That means actually without surrendering, they started paying tribute to the Mughal emperors. Therefore, even our great Muslim people actually then, Arcad, Nawab and everybody actually gets a right to collect tax. This is how actually we, and before British government, owner is a person who made the soil to be productive. It's a person who, you know, actually agriculture family ulla ellarukku theriyum ungalku neenga vandu how it is difficult to actually make fit a land to cultivate. Very difficult. So in those days, during the king's time, only a person who, the tiller of soil, who made the land fit for cultivation was recognized as the owner. This is actually, and then slowly the kings actually started collecting what is known as actually kist, kist from actually the, for giving protection to this actually peasants, farmers, and then also sometimes to make them or enable them to market their products, so many other aspects. That is in only in lieu of service that was actually rendered by the king, the system of collection of revenue, land revenue was started. Then slowly the king also became actually the protector of actually the countrymen. Therefore, instead of collecting or actually a tax from everyone, the king actually focused only land revenue, because that will be very easy. Peasants always can be compelled to pay. Therefore, between 1/3 to 1/10 of the actual produce, the king started actually levying as tax or whatever is actually. It's not actually. So, king never claimed ownership over the proprietorship over the land, but he started collecting rent at the whims and fancies, depends upon. So, this was the position for a long time. And thereafter, king also appointed his own men, finding that actually these people will sometimes may forget to pay, or actually they are unaccountable. They started actually fixing land revenue originally on temporary basis, and thereafter a Karnam was appointed. Every village there will be a person known as actually headman. So he is the person who will be in charge of collection of assessment and collection of revenue, land revenue. And then the accounts are maintained by a person known as Karnam. So you all know actually the British government introduced actually Karnam Regulation Act along with actually that we will actually discuss later. So this is how the system actually started working even during the king times. When even before British government, lands in Madras Presidency was under two different tenures known as Mirazi tenure and Ryotwari tenure. Ryotwari tenure you all know, everyone knows actually. So it is the present, most of the, actually 90% of the land are covered by actually Ryotwari tenure. And then what is Mirazi tenure? This also, I was surprised to find actually in many parts of South India, particularly in Madurai and Ramanathapuram and Tirunelveli district, actually this Mirazi form of tenure is actually, it is a collective farming. So people, in order to get actually a bargaining power from the king or actually the ruler, so instead of paying actually fixed land revenue, they wanted actually collectively they wanted the revenue to be assessed, so that a single man will not be actually, there will not be any injustice to a single person who is the tiller of science. Suppose what happens when a revenue assessment is made, whether the land is under cultivation or not, he is compelled to make payment, and he will actually face all music for non-payment of this rent. Therefore, in order to do away with that, probably people joined together. So a common interest was created among all the villages. It may be members of the same family or different families in the same village, or 2 or 3 more villages joined together. They constitute actually this kind of a cooperative farming. So all are jointly, severally liable to the ruler to pay contribution. And it is actually a system of government in the sense, you all know, the 18 Patti Natama illa the Mirasi Tenure. So one person will be known as actually Natamakara, Ambalakaran, whatever name he actually depends upon the area. So he is the headman who will control the entire land, and his duty is to collect revenue and then pay whatever thing actually that is, and then spend the left out money for communal purposes. So he used to resolve all the dispute between actually the people. And very interestingly, so Mirasi Tenure, there will be people who will be doing actually different jobs which are required. Say for example, there will be a common blacksmith, there will be a common Madaviti or Vetian, or even actually people who do part actually, pottery, these Koyavargal, and so many other things actually. So one important is that there will be a person called actually Panjanga Pakadu, small amount will be paid. He will actually give the auspicious day for actually sewing, plowing, or actually conducting marriages. This is how actually it's like actually a small government actually. This is the Mirasi Tenure. And for example, actually I can give you in Sivagangai, so we have come across actually Kotayur Natar. Have you ever actually seen? I have conducted few cases for them. They are otherwise known as Eitkare Vallambas. So a suit was filed in 1943 for partition. It is still pending. So this is an example of actually this Mirasi Tenure. And then you all know that actually as far as actually the Mirasi Tenure, actually the system was perfect in the sense they wanted actually the ruler to collect actually. They wanted, it is at their instance, the ruler actually collect tax in 3 different forms. So for all Nanja lands, Varapata is actually issued in the sense from the actual produce, some percentage of actually the value or produce will be given as kist. And then for rainfed lands or Punja lands, Tirvapata. So the Tirvai and Varamara, actually actually Tirvai and kist, there's a difference, Kist is normally meant for, but it has now actually no denotation, all these actually things people forgot. But then this Tirvapata was given in respect of actually the rainfed lands or Punja lands, whatever actually. So cultivation depends upon rain, quantum of rain. Whereas actually Nanja lands means Nanja, a permanent source of irrigation provided by the government or the ruler. Therefore, the tax or revenue will be more for actually Nanja lands. And after Nanja, Punja lands, actually Taris lands are 2 different kinds. So one is actually Sheikal Prambu. So a land which was temporarily waste because of its weather. And there are permanent waste lands known as actually what is called Anadikaram, means actually is on the land, because actually there were litigations actually. A person, the right to hold wastelands itself is actually a subject matter of lease. Actually, there are variety of judgments right from actually our district municipal court here to actually Privy Council. This is an interesting aspect actually. Therefore, the British government actually, because actually there after the introduction of actually the permanent settlement regulation in 1802, probably this problem was to some extent solved, because actually the ownership now vests with the crown. Therefore, nobody can claim ownership over the wastelands. So that was the law, or that was the implication, legal implication of the provisions of permanent settlement regulation. But prior to that, actually, there were a lot of litigations, even for persons who hold some lands as wastelands. So they are expected to surrender it immediately, so that the person, the ruler, or actually the British government was in a position to give it to any other for getting revenue. And Porambok lands were indicated even before actually the permanent settlement. It's not actually a fault found by actually government, or actually it was long about actually 300 years. Actually this Porambok normally refers to a land which is not assessed to land revenue, please. And then as a matter of fact, actually we all know every land which is unfit for cultivation or which is classified as actually non-Ryotwari lands was also sometimes called as Purambok. So there are variety of Purambok land that we will see a little later about Purambok lands. Now, the concept of that is actually the land tenure in after British government actually changed, came to a new phase only when the British government introduced the permanent settlement regulation in 1802. This is an important before actually the permanent settlement regulation. You need to know there are actually major three kinds of grants also. Apart from actually the Mirasi tenure or Ryotwari tenure, three different grants also was recognized. The first is actually, we can broadly classify into three grants, mean beneficial grant, then personal grant and service grant, service income. So this beneficial is actually always, it was the custom of Hindu kings to grant assignment of lands free at low rents for services they rendered already. Say for example, a chieftain or actually a warrior who was instrumental or who was actually a hero of actually a particular war, he will be recognized for his service. And then a beneficial grant will be that actually both varams will be given to them. So he will be the owner holding both male varam and actually he need not pay any tax to the government, but he will be enjoying the land without any payment of rent or actually the male varam, which is normally assessed by the government. So, and then personal grant and the service norms are almost identical in the sense they are given in favor of an individual. So while service norm is heritable, so, personal income actually is only for the person who is in service till such time he holds service, he doing performing service actually is entitled to hold the property without any payment, without any liability to pay actually tax. And then all these lands were now come under the term estate, broadly speaking. So the term estate, please, if you go and then find out actually what is estate in any of the provisions of either Land Encroachment Act or the Permanent Settlement Regulation or even actually our minor Inam or Inam Estate or Estate in Abolition Act, so you will not be able to get. But actually term estate, you please understand every land in respect of which a land revenue is assessable or any land which is subject to land revenue is known as actually estate. This is all. So this actually, and then under the permanent settlement regulation, all the lands which come under the any definition, whether it is a grant or enam or estate or whatever it is form actually, it was treated as a property of actually British government. Then they gave actually the land, assigned these lands to either existing zamindars, even actually zamindars were actually present even during the British time. Even the kings actually had zamindars as intermediate to collect revenue as agent. But here, permanent settlement regulation give absolute right, the grant actually by way of a Kabuliat will give absolute right to anyone, the grantee, namely the zamindar, inamdar, mitadar, whoever it is actually named in those days. So they are expected to expect a Kabuliat which contains the terms of the grant. So ultimately, the lands will be treated as absolute property of the grantee, and he has got the right to collect or assess land, give it to anyone as lease or on any other terms basis, which are all called actually under tenures. And then the collection normally will be 2/3 of the income or the land revenue will go to the British government, rest will be taken by actually the town. This is the simple analogy, but the disturbing factor is that all our rights has lost their proprietary, which was all along recognized by the kings, by everyone. So then actually there was a problem. People actually also try to establish their existing, that's what is called, normally we used to say, pre-existing right. They fought, and then there was a clarification, one judgment. Therefore, 1822, there was an amendment to this. Therefore, it says the British government has no intention to abolish the existing rights of ryots or who were in possession of the property. So this declaration was made in 1822. But despite that, there was no amendment because the ownership was curtailed by the settlement regulation, but it was not actually removed in total. Therefore, by this declaration. But anyway, people actually, but again their right as such, as a owner, was never recognized by the British people in their action. Then 1802, they introduced actually the registration also. So, well, because British government then found the registration of transactions for because all 8% we are charging, 8 plus 3 we are charging now. In those days actually some 3 or 4% was also a good revenue for actually the, so then the registration charges was in terms of the land revenue was assessed. So they introduced this, even though the Registration Act, because I have not gone through the entire act, but I find there are judgments to the effect that actually question always raised was whether the transfer deed conveys title. No, because there is one provision that actually no transfer without the permission of collector is valid. So sometimes there will be litigations on that. So they will go before actually district collector getting permission for this. The collector only with the approval of the zamindar or whoever actually the landholder who was actually, they will approve actually such kind of transfers. So the transfers being litigious, even though actually they collect revenue for this, therefore that's also give a suggestion that actually the British government probably they did not recognize ownership, but only by the advent of Transfer of Property Act in 1882, because they had no other way. Then thereafter actually they started actually the recognize the title or proprietary right or whatever right that was in enjoyment of actually so it was no more possible for the British government to claim ownership over the land merely because the person failed to pay the land revenue. So this actually ensured only after 1882 Transfer of Property Act. This only I give actually for reference. Now, what is more important is the survey. Before actually coming into the three enactments, survey. The Paima survey was introduced in 1825 as the first, that is first quarter of actually 19th century, Paima survey. The Paima survey, the fixing the land with reference to boundaries, giving boundaries of others on the eastern side, northern side, and then the measurement was actually approximate. So it was not by any known method. And in 1857, the Cadastre Survey took place. Thereafter, 1997, the Survey and Boundaries Act was with them. Even then, actually, it was not actually the Madras Survey and Boundaries Act, 1997. So it was only from 1887, actually, survey was actually conducted. And this act was replaced now in 1923, the present actually Survey and Boundaries Act. So now the survey was started only in 1857. Please keep it in mind always whenever you go. Even the cadastre number or Paimosh number given earlier was replaced. Even now, today, there are few parcels of land which are not surveyed. So we can't call it by a survey number. Therefore, you keep it in mind. Therefore, there may be a case where the property will be referred to by actually cadastre number or Paimosh number. Even before survey, after the permanent settlement regulation, the British government actually wanted to bring out a legislation describing the relationship between actually the zamindars and the ryot whose liability to pay rent or actually land revenue to the zamindar, and how the zamindar is liable to pay actually the share to the British government. Therefore, the Tamil Nadu Estate Land Act in 1908 was brought in. So, Estate Land Act define the land estate because so any permanently settled estate or temporarily settled estate. This will be the definition. Permanently settled estate means whatever land that was actually given to the zamindar, mitadar under tenure and all under tenure lands. And then this also includes unsettled Palayam and Jagir Jalita. So this Jagir word actually is very important. So Jagir is a term which is used to denote the lands which were given to the military rank holders of Islamic or actually Muslim army. So in recognition of their service already rendered. So a person who is honored, who was rewarded with actually this kind of rights, Jagir, they will be given absolute right, both Melvaram and Kudivaram in respect of certain parcels. He will be in possession of the land without paying any rent. Therefore, the fact that actually estate also include Jagir means, so there are so many lands which have been enjoyed by actually the agents of Mughal emperors are actually the office rankers, rank holders of Muslim army said in that. And then Palayam, you need to know actually Palayam is again some people are called Paligas. Paligas means they were used by Hindu kings or British people to serve as actually policemen. Policemen are at the time of actually war also these people are used to be engaged by the government. So these people are given certain lands which are normally in hilly areas where actually people, so normally these people will be otherwise engaged in agriculture and at times they will be called. So British people actually were unable to collect land revenue from these people. Therefore, they were unable to get these lands under a settlement or even under the permanent settlement, these lands could not be actually taken. Therefore, this Palayam, the lands which are given to this Paligas, which could not be actually recovered from them or where actually no land revenue can be recovered. So these people have termed as an unsettled Palayam. So these are the definitions of estate actually you find in Act. Therefore, I am actually giving this. Otherwise, there will be some difficulty in understanding the term. Now, under this Estate Land Act, the purpose is to make clear the rights and obligations of the landholder and the heirs. So, how to fix the rent, what will be the basis of all these things actually come under this. The object of this legislation, as it indicated from the Act, is to amend the law relating to the holdings of land in estates in the state of Tamil Nadu. So the Act deals with exclusively the rights and obligations of the landholders and rights. The Act was to ensure every landlord to collect land revenue from the farmers. And similarly, the landholder is now entitled to approach court to enforce actually the right to collect land revenue, and the corresponding obligation is absent in this legislation. But anyway, ultimately this is to benefit actually collection of revenue by the British government through these intermediaries. One important provision under this Act is actually Section 20. Probably you all will have reference, because the district collector then had the power to convert any communal land into a land which can be assigned to anyone, and the vice versa. Say for example, if there is a tank which is abandoned for a long number of years, so the district collector will now reclassify it as a non-water body and then give assignment in favor of so and so. This Act was repealed when the first Act came in 1948, Act 26 of 1948, immediately after assignment. And now we will deal with actually the first enactment after independence. First, actually, reduction of rent and arrears came in 1947. So, immediately after partition, this is after actually independence, the government thought actually the peasants or the farmers who are in the clutches of actually the zamindars should be freed. Therefore, the reduction was drastic. It became actually less than 1/5 of actually the amount by this. And second enactment is Tamil Nadu Estate Abolition and Conversion to Ryotwari Act, Act 26 of 1948. This is the object of the act is to abolish, acquire the rights of zamindars, all intermediaries who are appointed as agents by the British government to collect land revenue. By this act, உங்களுக்கு எப்போ எல்லாரும் சினிமாவில் சொல்லுவாங்கல்ல, குடியானவருக்கு தான் உழவு நேரம் சொந்தம்னு சொல்றது இந்த ஆக்டில் தான். Please remember this act. This act, it is not actually the Agriculture Record of Tenancy Rights Act. அப்படி இல்லை, நிறைய பேருக்கு அப்படி ஒரு சின்ன மித்து இருக்கும். இது கேட்டாச்சுன்னா குடியானம் அப்படின்னு சொல்லுவாங்க. So the Ryotwaris in this country originally are owners, but their right to hold land became actually subject matter of litigation because of the permanent settlement regulation. Now by abolition of permanent settlement regulation and introduction of this abolishing are the rights of intermediaries, every owner, that is every Ryot, is recognized to be the owner. As a matter of fact, actually, as per the act, entire land which is defined as estate vests with government, free from encumbrance, but subject to the right of Ryotwaris to get Ryotwari Patta under the act. This is more important. Our courts have interpreted actually these provisions that actually the government actually is not taking over than giving. No, it is subject to the rights of Ryots to get Ryotwari Patta, to get actually the title document. The government takes over the land. This is all. So under the act, there are provisions by which Ryotwari, that is Ryot, is entitled to claim Ryotwari Patta, and sometimes the landholders also entitled to Patta. Say for example, suppose if Zamindar is doing personal cultivation or cultivation through labors personally, or the lands which are known as actually Pannai lands, so he can claim Ryotwari Patta. So Patta will be given, and then the land is also, the vesting of property is also not only with reference to estate but also with the Inam lands, estate Inam, what is known as actually. So except this Inam which is covered under the Estate Inam Act, which is Act 26 of 1963, all lands, nearly 90% of the land vest only with the government only under this act. So under this act, 90% of actually the Ryotwaris, their right was crystallized to get actually Ryotwari Patta. Therefore, the settlement actually starts from here. So the topic actually, the importance of the topic starts from here. What would be the position of Ryots who are entitled to Ryotwari Patta? Under section 11 of the first act, so whoever is in possession doing cultivation or as a Ryot and the land is subject to land revenue, he becomes the owner. That was the idea. Therefore, once actually Ryotwari Patta is given, so his right is only to pay land revenue to the government, nothing more. Then, under the provisions of this act, there are few litigations which came later. So the question is, when a settlement proceeding started by the assistant settlement officer, so an application is supposed to be given, or without even application, on the basis of the Karnam, who is supposed to prepare the records, actually will produce records, and Ryotwari settlement was started actually, and then giving Ryotwari Pattas to individuals. What happens if a person doesn't claim ownership by claiming Ryotwari Patta? So the government extended actually till 87, even though the period was only 3 months. So every Ryot is supposed to make an application within 3 months from the date of notification, because actually even though the act actually was introduced each village actually a notification will be issued taking over the land. So all the estate lands, which are sometimes actually several number of villages, were taken over and by individual notifications. But people have not actually, because unavailable. The settlement were conducted mostly in Madurai, Tanjavur, and in Ramanathapuram. The settlement officers used to, for entire south, yes, caption. So therefore, and many times actually the Ryot were unable to get actually or made applications. Therefore, the government actually extended the period of limitation till 1987. I remember it was in September 1987, the last date. In those days, actually, the British government was collecting revenue. Actually, my approximation is a calculation actually. So, there are lands which will give at least 5 rupees per acre per annum as land revenue. The due will be, so it will be calculation actually. So, it was then when actually the dollar rate was actually 17 paise. So, $1 is equal to 17 paise. At that time, the British government was collecting 5 rupees per acre in far as actually a triple crop Nanja lands. So, with the permanent source of irrigation. So, that was actually, therefore, the government at the time of this Ryotwari settlement was keen in making the Ryotwaris actually liable to pay tax, because the income was only, the main income for the government at that time actually was only land revenue, like British government. Therefore, what happens is, so during settlement, I am told actually by a retired district collector then, so if a case comes to him saying that a person is assessed to tax at the time British time by paying actually to the Tahsildar, to the Inamdar or Mitadar or actually Zamindar, and his land is not actually, now Ryotwari Patta is not issued to him, then immediately there will be a charge memo for actually major punishment. So this is such a actually grave offense when this was actually but today people actually, the whole thing has changed now. Yes. So therefore, people used to know actually those lands were unable to, so it is common now actually after 1980s, there will be several lands will be classified as Tirvayarpattu Tharis. It's very common. Wherever actually Tirvayarpattu Tharis means the land is assessed to tax, but still the government actually Tirvayarpattu Tharis Purambok. So that means they are unable to identify the person who was paying actually the land revenue to the government. This is how actually there was a mess by revenue people. And then some of the classification during actually settlement, Anadinam people all actually have. Anadinam is actually normally denoted as unoccupied land. So the real meaning is Anadina means a property which is not under the control of anyone. But there are two judgments. One is 1983 Kerala, and another is 1957 actually defining what is actually Anadina. Therefore, merely because when somebody says claim ownership over the land, prove enjoyment at one point of time, so the land cannot be treated as Anadinam. It will never be the property of government anytime. So this is how actually under the settlement, then there's a problem. What happens when the person has not pursued his application or he has failed to establish his right to get Ryotwari Patta? Still, it is open to him to, so an appeal actually is provided to tribunal. That means actually the district court. Thereafter, he is finished. But 1969 actually, the judgment in Ramalingam Madam's case came. So it was a case where the temple is was entitled to Ryotwari Patta. They claimed Ryotwari Patta, it was not granted, and ultimately under the Estate Abolition Act, Act 26 of 1948. So, and then there is one provision under the Estate Abolition Act, 64C. Any order passed by the authority under that will be final and it cannot be challenged in civil court. This was examined by division bench. Division bench held so that finality is only for the purpose of land revenue. Therefore, it will not actually become final. Civil court is competent to decide the question of title when the issue relates to it. So this is a wonderful judgment because as far as always actually our High Court has taken credit for applying their mind. What would be the reality if these people go before revenue officials to decide? So even today actually there are so many judgments. I can tell you about 100 judgments during up to 1950s. How the court should be guardian, take the role of a guardian to protect the rights of innocent people actually. So if it is actually made available to the British or revenue people, actually they will dislodge the whole thing. It was a wonderful judgment by division bench. That judgment was confirmed by Supreme Court in again 86 Supreme Court, Ramalingam Madam's case. It was a judgment actually on two aspects. First, actually they said the civil court's jurisdiction. So despite the finality under section 64C of the Estate Land Act, the finality is only for the purpose of that. Civil court's right or jurisdiction is not ousted because section 9 actually is very broad. It actually gives the power of civil court to decide everything unless it is specifically. So the bar under section 64C was interpreted only for the purpose of the act. So remember, this judgment was in 1984, but whereas in 1995, Justice K. Ramaswamy gave a different verdict as far as the provisions under the similar provisions which are pari materia with our act in Telangana. He said, no, civil court is not competent. Therefore, the matter again came up for consideration by a full bench of this court. In 1998, 2 CTC by Justice D. Raju and others. They reiterated and then they went to the extent of observing that. So sometimes actually by the civil court verdict, the verdict of the settlement officer may become redundant or actually maybe rendered, it may have the effect of rendering the verdict of actually so-and-so invalid. Even then, civil court is not actually incompetent to decide the question of title. And then they refer to actually several judgments on principles which have been settled by this court, long actually number of cases. Even I remember with reference to similar issue arises with reference to the provisions of HRMC Act. In HRMC actually section 63B would say that it is for the deputy or joint commissioner to decide whether the office of trusteeship is hereditary or not. So, in a judgment rendered by this court in 1976, actually by two eminent judges of this court, they interpreted what would be the position, whether the civil court again can go into the question. So, the division bench interpreted the right to office is not decided, or there is no machinery provided under the HRMC Act to decide the dispute as to between who two actually trustees claiming ownership or actually right to be hereditary trustees, who should be chosen. Not for the authority under the Act to decide, but only for the civil court to exercise and then based on evidence will decide. Only character of office, whether it is hereditary or not, will be decided, not actually the right between parties, whether A or B is a hereditary trustee. So, it was a case where the law settled was in a suit, in an application between two groups claiming trusteeship over a temple. So, the authority, joint commissioner decided that A group is a trustee, he is the hereditary trustee. So, whether again actually sometime later the issue decided was the temple, the office of hereditary, in that dispute actually the decision taken by the joint commissioner was office is not hereditary. But later this issue came before actually the court in a statutory suit later. So this judgment, the finality of the decision was actually tested by the civil court and then it went on appeal. And appeal it was held that the decision that was rendered by the joint commissioner in the inter-se dispute between two factions claiming trusteeship is not final. Therefore, the civil court is competent to decide the character of also. That was actually the decision you may refer to this actually. Then the other aspect of the case is after this 1948 Act, there are two acts, that is Act 26 of 1963. That is estate Enam estate. So Enam estate actually, so under the first act, some of the Enam, like Pudukkottai actually, Enam lands actually belong to the Maharaja Pudukkottai and Ramanathapuram Samasthanam. All those land grants were not included, therefore they specifically refer to. And then somebody challenged the provisions of Estate Land Act, saying that the act has no application to minor Enam. Minor Enam, so you should know minor Enam is actually something, is not actually such a complex issue. Minor Enam means actually if the grant is in respect of one or more villages, it is called major Enam. So if the Enam is in respect of a single village or some of the part of the estate in a village, then it is called actually minor Enam. So the minor Enam, Enams, normally actually service Enam granted in favor of actually the archagas of temple or perform who are doing pujari, who are doing pujas in the temple, they are given the grant in lieu of their services that are expected to render in actually temple. So a litigation, there was a writ petition filed challenging the applicability of the act in respect of minor Enams, saying that. Therefore, a special enactment came called actually Minor Enam Abolition Act. It actually, sum and substance is the same provisions as in the case of others. Now, after these three enactments, so we have the Patta Passbook Act. So now we have, under the Enam Abolition Act, there are provisions by which the landholder also were given compensation. So temple was given certain rights. Say for example, when the land was held by temple and no Ryotwari Patta is given, or a temple is found to have actually exercising the right of landholder, then a tasdik allowance is also given to the temple by the government. The land was taken over, but almost the income from the land was directed to be given to the temple. And there are several other provisions which deals with actually say for example, section 19 of the act is in respect of actually ground rent patta. Section 19A refers to ground rent patta, which can be given to a person if he is put in possession by the landholder just prior to the act in respect of non-Rayati lands. So, but not actually communal lands. Non-Rayati, but not communal lands. Then he can be given actually allowed to be enjoyment of properties by paying what is known as ground rent. So there are other provisions which leads to, and then the power of Director of Survey and Settlement is actually very important, because often interestingly we came across a case where actually Ryotwari Patta was given in favor of group of people who are owners, who also have actually the right to collect tax as well as the Kudivaram right. A landholder purchased actually the land from the right from actually the rights. So become actually holder of Iruvar at the time of actually even before actually the settlement. So he was given settlement actually Patta, that is Ryotwari Patta, in recognition of his right as a landholder as well as actually acquiring the rights of rights. Now what happened after several years later, so somebody claimed actually Ryotwari Patta. His modus operandi is actually he filed an application before the settlement officer saying that actually my predecessor in title actually, that is actually the persons who conveyed their Kudivaram rights in favor of the landholder. So I belong to the family, therefore I am entitled to Ryotwari Patta. My predecessor in trust has not actually joined in the sale deed executed by. So this application was entertained after all these years in 1996 or so by the assistant settlement officer. But he found on record that actually his father also was involved in actually the transaction, therefore nothing doing, he rejected the application. Thereafter this man went before actually by way of appeal before the settlement officer. Settlement officer also rejected on the ground of delay, because after the order passed by the, he has to file an appeal within 30 days because the appeal is actually only on that ground. Then he took the matter to the Director of Survey and Settlement, now passed an elaborate order saying that there are a lot of irregularities in the grant of patta, all those things. Therefore, the order granting Ryotwari patta cannot be so and so and so. The question is whether he has any power to suo moto entertain any application revision, because he exercised the power of suo moto revision. An objection was raised before him saying that actually you have no power to exercise your suo moto power, because the suo moto power is available only if the order passed by his subordinate is not appealable. Here, as against the order granting patta, there is a remedy by way of appeal before actually the tribunal, that is actually the district court, which is designated under the Act. Even though I am not entitled to actually exercise my suo moto power, now I find these irregularities are fraudulent, so some fraudulent entries, therefore I am entitled to now condone the delay in filing the original appeal, and then therefore for all these reasons I set aside the order. Actually I don't know the reason behind, logic behind this actually. So this all happens only by revenue bill. This Director of Survey and Settlement, please note, only an officer is most corrupt will be given this position. You take it, I am not joking actually. So it is only to settle, unsettle actually the so many things actually. So this man will now actually settle not several proceedings actually which have become final inter partes. So then in some cases, of course, actually people will go to the land commissioner and then so recently one case came. A tank was occupied by several persons. So 50% the tank was actually is in their occupation. So this Director of Survey and Settlement actually directed the officials to give ground rent under Section 19. I told you actually the ground rent actually is possible only if it is a non-Ryotwari land but not a communal land. Now tank bed actually comes under the definition of communal lands, please. So remember, therefore he has no power to, but actually he wanted, so he regularized actually about 500 people who are in enjoyment of the land by single stroke. And it was also revealed that actually the actual persons at that time was only 50. Now all the 450 joined later. So this litigation was pending before principal bench from 1988 or so, but in all those cases actually they were successful in getting orders directly consider the representation to give patta and all. So I had to now actually dismiss all those repetitions on the interpretation of Section 19, that's all. So yes, it may be ultimately open to the government to now find out alternative layer, because they all put up actually massive constructions in the land. This is how actually our system, Ryotwari system actually. Now what would be the other legal implications? You please actually, I wait for a moment actually, I invite some of our young members to ask questions or raise their doubts with regard to application of any principle. UDR. Yes, what is UDR? So, paradise. UDR, it's only updating registry. It was introduced by virtue of actually GOMS number 525, if I remember, maybe some right. It was in 1982. So the object behind actually this UDR is to carry out the, not actually a survey, but only to update registry. Because after actually the settlement, say immediately after settlement, the A register was prepared. So which will contain actually the measurements in actually hectares, acres basis actually. So the metric system was changed. So the government wanted actually to redo the whole thing. So the measurement was also given, started actually, the government gave instructions that actually the metric system should be converted from actually acreage to hectares. So you all know actually 1 hectare is equivalent to 2.47 acres. So this is how. And except this modification with regard to, there is absolutely no statutory backing for this UDR. But UDR, because it became actually mess later time, so government actually passed another executive. Errors in UDR can be complained before the DRO. So DRO is the person who can now actually modify the records. Of all actually in the Patta Passbook Act, now we'll deal with that. Under this act actually, a owner is defined. A person holding land in severalty or jointly under a Ryotwari settlement. Please remember, therefore a person who is entitled to Ryotwari Patta, whose right is recognized by the settlement authorities under the or only a Ryot who obtained Ryotwari Patta in recognition of his pre-existing right to hold the land under the Zamindar so and so, so and so. So he is entitled to Patta. So this Patta is actually a document of title, because actually the government now take over the entire village subject to the pre-existing right of riots to get Patta. Therefore, we all recognize the title of a right only under the Ryotwari Patta. Once a person is given Ryotwari Patta, it is a prima facie document of title, please remember. So, it is in that context, even a division bench of this court, probably I remember in 1995, after actually the two judgments were, when an issue comes before court challenging the order passed by the DRO in relation to Patta proceedings, this court expressed, so this court will not go into the issue whether who is entitled to Patta. As between two persons claiming rival claim over Patta, one of you can go on before civil court and establish your title. So on the basis of title, Patta will also be changed. This is what actually the direction. But as far as actually revenue or Ryotwari Patta is concerned, it is actually a document of title. Therefore, Tahsildar under the revenue under Patta Passbook Act is not supposed to touch actually the Ryotwari proceedings or settlement Patta granted in recognition of anybody's right to hold Ryotwari Patta. This one aspect of the case. Therefore, the owner itself, the definition of owner itself gives an indication that the revenue officials are Tahsildar, revenue divisional officer and DRO. They are not supposed to touch any record prior to the basis of Ryotwari settlement. If A is given Ryotwari Patta, these people have no business to change or correct actually the name. Then the power to modify records actually is given under section 10 of the Act. It is only on two contingencies. One is if by transfer inter vivos, suppose A transfer the land to B, then Patta can be changed from A to B. Similarly, if a person dies, so all is legal as by devolution of interest they are entitled to get Patta as a matter of right, except to this and under section 14, so by a declaration of civil court decree declaring one's title, so if he should be given Patta. Therefore, the civil court decree, because 14 is very important. Therefore, when a person gets a declaration from civil court as to his title, so the revenue officials are under an obligation to give they are bound by actually such decree, and then they have to change the revenue record in accordance with that. Then this act also, so the Tahsildar shall issue Patta to every owner on application. Presumption as to the correctness of entries in Patta box is given under section 4, and no document to transfer any land shall be registered by the registering authority without actually Patta under section 5. This is an important provision. It is only by virtue of section 5, all your registering officer will insist actually Patta. So it is not necessary that actually Patta means only the person's name. If found in actually he is entitled to transfer, it's not so. Suppose your father is the holder, so you can also actually go and register a document on the basis of actually your legal heirship certificate. Section 6 though says entries in Patta Passbook Act shall be prima facie evidence of title. But without reference to section 6, There are umpteen number of judgments, but all those judgments are hold good actually. So all those things actually they refer to the patta, which was issued by the landholders originally. That is actually the intermediaries appointed by the British government under the permanent settlement regulation. If they give patta, that document, that is not a document of title. Similarly, suppose under the Estate Land Act, so every landholder is again actually is entitled to, is directed to give patta for actually all the rights who are holding the land and paying land revenue to the government as to law. Therefore, Patta Passbook Act, now today it should be interpreted that if a person gets revenue patta in continuance of his right as a owner under the, by getting a Ryotwari patta under the settlement, then it is a document of title. So please, if anyone actually want to have actually find out whether a person actually is entitled to patta or actually entitled to claim ownership on the basis of the revenue patta, please trace your right from actually the settlement. That is very important. The heir register prepared immediately pursuant to the settlement. That is actually settlement under the 3 enactments. If your land is covered under Act 26 of 1948, that is Estate Abolition Conversion to Ryotwari Act, or under it's an innominate estate as defined under the second Act, Act 26 of 1963, then you trace your title from there. And then if you are unable to trace, but you are quite sure that you are person in possession, and then all these years, your right is still protected by getting a declaration from civil court against anyone who is challenging your decree. So this is the way which we can infer from actually the catena of judgments, right from actually Ramalingam Madam's case and the full bench, and thereafter so many other judgments. It may be a good case for your client. Go with the knowledge you acquire, actually go search something more actually. You'll be able to get justice to your party if really he deserves it. That's all. With this I conclude my speech. We'll continue on the next occasion. Thank you.
Thank you, Lordships, for enlightening wonderful lecture. We really enjoyed, Lordships.
Now it is time for vote of thanks, and for that I would like to request the General Secretary of MMBA, Aayiram K. Selvakumar, to deliver his vote of thanks.
அனைவருக்கும் வணக்கம். இப்பொழுது நீண்ட நேரம் 6 மணி நேரம் உட்காந்து ஜட்ஜ்மெண்ட் சொல்லிக்கூடிய நம்ம லார்ட்ஷிப் இன்னைக்கு கிட்டத்தட்ட ஒரு 2 மணி நேரம் நின்று பேசியிருக்காங்க. எப்பவும் கோர்ட்லேயும் ரொம்ப நேரமாக வழக்கறிஞருக்கு ரொம்ப நேரம் பேசிகிட்டு இருக்கவங்களுக்கு இது ஒரு டச்சு வந்த மாதிரி ஆயிடுச்சு. அதுதான் வள்ளுவர் சொல்லியிருக்கிற தொட்டினை தோறும் மணற்கேணி மாந்தருக்கு கற்றனை தோறும் அறிவுன்னு. எப்படி மணற்கேணியை அள்ள அள்ள ஊற்று பெருகி அந்த தண்ணீர் மற்றவங்களுக்கும் அவங்களுக்கும் அந்த கேணி நல்லா இருக்குதோ, அதே மாதிரி அவங்க கற்றுக்கிட்ட அவங்களுக்கு தெரிஞ்ச ஞானத்தை நம்ம கூட பகிர்ந்தது மூலமாக நமக்கும் பலன், அவங்களுக்கும் ரெஃப்ரெஷ் ஆகிட்டாங்க. ஸோ on behalf of MMBA, our sincere thanks to the Encyclopedia of Civil Law, His Lordship Justice S. SUNDAR, Administrative Chief, for his wonderful speech about the subject. And our sincere thanks to the Senior Counsel, Mr. Krishnaveni Ma'am, Balasundram Sir, and Mr. B. Saravanan, and all other Senior Counsel, T.S. Sir, Venkataramana Sir, and Law Officer AAG Sir, and Kannan, Ashok, and Saji Bino, S.R.A. Ramachandran. Unexpected spectator here is His Lordship Justice Bharata Chakravarti, and our sincere thanks to our founder President Mr. Isaac Mohanlal, and all other civil dignitaries. And I think I am informed that so many civil officers and the clients are disappointedly waiting for their counsel, since all the civil luminaries are present here for the hearing of this beautiful series rendered by His Lordship. And our sincere thanks to the host of the today event, Senior Counsel Mr. Kadirvel Sir, and comparing done by Mrs. Deepa and Mr. Saktivel, Executive Member here. Actually, President was dreaming about this event, and he quite often would say about the topic as well as the speaker, and I think his dream is come true today. Thank to everyone. Thank you.